Okay, Classness requirement under charge is it must be clear or certain and not vague. Okay, vague also means unclear. So the charge itself must state the grounds on which action is proposed to be taken in a clear, specific and ambiguous terms for it to be meaningful. Okay, and ambiguous means that charge itself must be very clear. Alright, specific for example. So allegation, for example, allegation of cheating during final examination. So the disciplinary board, okay, when they give letter to attend the disciplinary proceeding, the letter must state clearly the particulars such as date, okay, time, venue, cause, witness, okay, for the particulars of the charge. Okay, so mesti ada the requisite elements. Alright, as you can see in the case of state of Uttar Pradesh against Salik Ram Sharma, all Indian report. In this case, okay, the notice or charge given to the accused in this case was not clear because the charge stated without specific details. Okay, so basically the allegation made against him is regarding the allegations of fraud. Okay, however, they failed to mention any particulars. Okay, so the charge was not valid. Okay, as it was not clear and specific. Okay. Okay, next requirement of charge. Charge may or may not include the type of punishment or penalty. Okay, when you given the charge, the allegation to the accused, okay, it is not mandatory for you to state the punishment or the penalty if the accused is proven guilty. Okay, however, it may becomes mandatory if the parents act. Yes, if the parents act confers the power to the authority to state the punishment or penalty. Right? So it depends on the legislation referred in the proceeding. Okay, as for the disciplinary proceeding in UiTM, okay, normally if you can see the letter to attend the disciplinary proceeding, it also provide the proposed punishment if the student is found guilty. Okay, so this punishment is stated in Kaedah 48. Okay, Kaedah 48. Sorry, sekejap. Okay, kaedah 48 atas 174 Okay, the case in point here is case of Nordin Haji Zakaria and another against Muhammad Nur Abdullah in 2004. So in this case, based on the regulation used in this case, the requirements of penalty to be mentioned in the notice apply only to senior officer. So there is no mandatory requirements to be followed, and it depends on the legislation. It depends on the parent act. Okay, next, the next requirements. Okay, we need to determine whether it must be in writing. It here refer to charge. Whether charge must be in writing. Okay, so it is not necessarily so unless the individual concerned is prejudiced because it is not made in writing. For example, if that person is suffering from a lack of hearing problems, so dia ada masalah pendengaran, okay, you cannot hear, so you must provide charge in writing. Okay, but it is advisable to have a written charge, okay, because you can use this document, okay, as a proof in court later if there is any dispute later. Okay, basically there is a case here as you can see in your textbook. Case of Limco against Board of Architects 1966. Okay, in this case, the court rejected the petitioner's complaint that he was not given sufficiently detailed notification of the charge made against him by the Board of Architects. Okay, because it was satisfied that the petitioner was sufficiently made aware of the nature of the acts of misconduct alleged against him. So if the person if the person is able to read, okay, he know being given a clear and specific charge, so dia dah tak boleh argue lah, right? Okay, next, the requirement of time, okay, under notice. Okay, notice must also give sufficient time to the accused to prepare his defense. Okay, so time must be sufficient. Cannot ask the alleged person to show cause immediately without giving him or her time to consider the charge against him. Okay, so you cannot give a person later, okay, or to dismiss him immediately, for example. Okay, you must give time for him to prepare defense. Okay, so how depends on each individual case. How we determine whether time is sufficient or not given to the accused? So depends on each individual case. More serious case, more time should be given to the accused. Okay, so in UiTM normally we give at least we give about 6 days to the student to prepare the defense. Okay, for example, kalau you nak bawa the witness, okay. Okay, as for example, in the case of Pang Mohsin against Commissioner of Police, in this case, the accused, the plaintiff was accused of corruption, and he was called for a hearing, but was told of the charge against him just before the hearing commenced. Okay, sebelum start hearing tu baru dia tahu the allegation made against him. Okay, so the dismissal made by the public authority was void on the ground of insufficient notice given to him of the charge made against him. So if this requirement was not fulfilled by the public authority in making decision, then the decision also considered void. Okay. Now we move on to the next elements. Elements under audio ultra pattern, elements of hearings. Okay, this should be in the next video.